5 tips to squeeze a little bit more money out of your car crash case in Indiana. This video is for people that are trying to negotiate a car crash case on their own without an attorney. The big reason someone would not hire an attorney is if they were not really injured, or maybe only went to the doctor once or twice, maybe an ER or urgent care visit followed with a primary care visits. But medical bills are very low and the injuries were not very severe. So if that's you, here are some tips in trying to negotiate your own car crash settlement. But these tips can really be applied to any type of injury. So these tips are designed to be used when you and the insurance adjuster for the automobile insurance are at an impasse. You're not making any headway. You want X and they want Y, and neither you is willing to go any further. So here are 5 tips to try to squeeze a little bit more money out of the adjuster. Number 1, ask him, what is your check writing authority? The insurance adjuster may not be able to give you any more money because they're at the top of their ability to give you money. Insurance companies are designed so if your claim is labeled an X, well then there's only X authority to settle that case unless a supervisor gets involved. So just plain ask the adjuster, what's your check writing authority? Do you have the ability to give me what I'm asking? Now, they don't have to answer you, but they might. They might say, hey, actually, I don't have authority to do that. But I can tell you my supervisor will never agree to more than this. Well, I mean, cool. I want to talk to your supervisor. You don't want to do that until you know you're at the top level or until you just really burned every bridge with that adjuster, because you may not like the supervisor any more than you like the one underneath him. But if you're at an impasse and you're not willing to give you any more money, straight up ask, what is your check writing authority? What can you actually give me? Do you have the authority to give me what I'm asking? In a perfect world, and you agreed that I needed what I just asked for, could you actually give it to me? And they don't have to answer, but they just might. But it also lets the adjuster know that perhaps you are smarter than the average person trying to handle their own car crash case. Number 2, ask the adjuster what they think the negative facts are in this case. Just ask them. And it's kind of an open-ended question. Maybe they'll tell you all the things they think that you did wrong. Well, you said in the initial recorded conversation that you could have been paying a little bit more attention. You said that you weren't really hurt. Well, in that first recorded conversation, you never mentioned back pain. You just mentioned arm pain. But they very well could say, well, we know our guy is not perfect. We know he was speeding. We know that he has a terrible driving record. So just ask him, what do you think the negative facts are in the case? And that might just get them talking. Now, that's useful so long as you've not completely just alienated the adjuster. You still have a relationship where you're talking. Because, again, pays to be nice. They're not your friends. It does pay to be nice. So keep that in mind. And then when you ask them what they think the negative facts are in the case, make sure you're writing that down. Make sure you're writing what they're saying down as fast as you can. The third tip, after you've asked them about the negative facts in the case, ask them point blank, what percentage of fault do you believe your insured is at? Now, this is a power move when you ask them what percentage of fault do you think your insured is at? Because that lets them know a couple different things here. Indiana is a comparative fault state, meaning you can be 10% at an accident, but the other person's 90%, and you can still recover 90% of the case's value. You can be 20% at fault in a case, and you can still recover 80% of the case's value. But when you ask a question like that, what percentage do you think that your insured is at fault? It lets the insurance adjuster know that you are, in fact, smarter than the average person trying to handle their injury case on their own. It also sends a message to the insurance company, particularly that adjuster, that perhaps you know something about insurance law, tort law, personal injury law, that maybe they were assuming you did not know. It's a power move. Now, again, they may not tell you, or they may say, hey, you know what? We think the guy's 25% at fault. The fact is, we don't think that your injuries are related because X, Y, and Z. But get them talking, and you're taking notes on what they're saying. And again, don't get mad if they say, oh, it's not really for me. I'm not a lawyer. They might say, I'm not a lawyer. I don't know. They know. They have a calculator program that's on there, and it says this case is worth X reduced by this. You'll get a bonus if you only pay this. They know, and they know the fault percentages. But by asking that question, you very well might get them to give you some more money because they recognize you might be someone smarter than the average person trying to handle their injury case. Tip number 4, ask them point blank, hey, well, I need more money because my out-of-pocket expenses are X, Y, and Z, and I need you to account for the out-of-pocket expenses. Their first response is going to be, well, this amount we previously offered does include the out-of-pocket expenses, so it's already been accounted for. Just point blank tell them, I don't think that's fair. This is for my pain and suffering, not for my out-of-pocket expenses. Those should be on top of the pain and suffering. Again, when you ask a question like that, you send the message to the adjuster that you know what you're talking about. Even if you don't, you can at least use these tips to kind of imply that maybe you do, to try to get some more money out of the adjuster. Now, the 5th and final tip, try to squeeze a little bit more money out of the insurance adjuster in a car crash or other injury case, is ask them, are they going to be taking care of the medical liens? Now, the medical liens are like this big black hole in injury law. If your car insurance paid some of your medical bills, which is very typical in Indiana, if your health insurance paid for some of your medical bills, which again, very typical in Indiana, if Medicaid, Medicare paid for some of your medical bills, which again, very typical in Indiana, then guess what? The person who was injured, when they get that settlement, has to pay back health insurance, car insurance, Medicaid, Medicare. It's called a lien. There's all sorts of liens in Indiana, and people that are injured often have to take care of those liens if and when their case is settled. So ask them, hey, are you taking care of these liens? They may not even know if there's a lien. They might just do the easy answer. Well, I don't know about no liens. This is a settlement for your injury case. That's your responsibility to take care of liens. I don't know nothing about that. I don't know your health insurance. I don't know your automobile insurance. That's all lies. They do know your automobile insurance. They do know your health insurance. And they even know if you have Medicaid, Medicare. They do, because they're insurance companies. They all share information. Well, HIPAA violation. It's not HIPAA. They know if you have those things, but they're not going to acknowledge it because they don't want to pay you more money. But if you say, hey, wait a second, I have X lien, Y lien, Z lien. These liens actually are 45 to 50% of what you've offered me. So you've actually only offered me half or a third. Or actually, we've had lots of cases people come to us a year later. They've only offered me the amount that's equal to my liens. I don't get anything. That's just ridiculous. So ask them about the medical liens. Again, when you ask about the liens, it sends a message to the adjuster that you know more than the average person trying to handle their injury case. And that very well may be a way to squeeze more money out of them to try to settle your case. Now, if you've watched this long, it's super important. Always get an opinion from an attorney before you try to handle an injury case on your own. Every single attorney I know that does injury law will talk to a person about their injury case. And in this law firm, we talk to people at least once, twice a week, if not more. That, hey, you don't actually need an attorney for your case. Just try to handle it on your own. You're not really injured. You don't really have that many bills, but still try to get compensation. You owe it to yourself to at least talk with an attorney to try to get an idea of what's going on. And watch my other videos. You want to keep documentation. You want to know exactly what you're doing, because once you settle your case, it's done. You can't go back in time. Well, actually, I forgot about my arm. I forgot about my back. It turns out I have a broken knee. Can't settle any of that once the settlement's signed and done. It's finished. Can't go back in time. Here at the Marc Lopez Law Firm, we understand that people who have been in car crashes and other injuries experience a significant amount of frustration with their situation. Allow the Marc Lopez Law Firm to turn that frustration into compensation. Give us a call, 317-632-3642.